May I please, Lordship? Item number 12, I mentioned to item number 12, adjournment hold the day, for the day.
You have to
Because
wait till the matter is called. All matters we are not adjourning without looking at the records.
May I please, Lordship? I'd like to mention item number 4. Lordship, we have not submitted our adjournment slip yesterday.
We'll have to wait. It's a 2017 matter.
Lordship, I
Unless
don't
it's
have.
called, no, unless I look at the file, we are not adjourning any old matters.
Please, Lordship. Lordship, the Engaged Counsel on item number 10, Engaged Counsel Mr. Huda is about to come, but due to some difficulties, unable to come. So the matter will be adjourned.
We'll call the records there only. Without looking at the records, no adjournment. All matters, we are not adjourning any matter.
Lordship, Mr. Huda is about to come at the
We
morning
are not on that.
due to some
We consider
difficulties.
that there only when the matter is called. Without looking at the record, we are not adjourning any matter.
Obliged.
Supplementary item 17 to be spoken to.
Yes, what is the mistake here?
Mention was made for correction of the order, my lord, passed on 16/2/2000.
What's the mistake?
6 minute. Kindly see me at page 4. Respondent number 6 minute. Respondent 6 should be there
Vishwanath.
in place of SP border Sunitpur.
No, what is wrong? We have, this is Vishwanath.
Vishwanath, madam.
We have written Vishwanath only.
Yes, madam.
Then
Vishwanath should be there in place of SP border Sunitpur, madam.
oh, acha, acha. Okay. There's a mistake in name, huh? But Mr. A. and Ahmed, counsel for the petitioner and Spencer for the respondents. Next, the matter has been brought on mention. It has been listed on mention made by the learned counsel for the petitioner. Next, it is submitted that the respondent number 6 in this writ petition is the Superintendent of Police, the bracket border, Vishwanath. However, though the said authority is referred to in paragraph 2 of the order dated 16/2/2026, but in paragraph 6, 7, and 8 of the said order, instead of Superintendent of Police border, Vishwanath, a reference has been made to Superintendent of Police within bracket border, it was Sonitpur, page 2. Next, accordingly, it is provided that in paragraph 6, 7, and 8, the reference to the Superintendent of Police border, Sonitpur, Tejpur, shall now be read as Superintendent of Police within bracket border, Vishwanath. Next matter. Is it accordingly 10 days from the date of this order is granted to the petitioner to appear before the Superintendent of Police border within bracket border, Vishwanath, and submit the bail bond in terms of the order dated 16/2/2026. Next point is order shall be read together with the order dated 16/2/2026, lasting this rate petition. Next point. As stated in the order dated 16/2/2026, list after 4 weeks on the city report.
Item 8 may, it may be taken at, I have some personal problem, it may be taken at 2 p.m.
Which one?
Item 8
Item 8.
at 2 p.m.
Supplementary list, item 18 for motion.
May please, your lordships. Lordship, the impugn order starts at page number 64, my lord. Judgment delivered on 6/7/2021.
Good explanation for the delay.
Lordship, paragraph 18, I have stated, my lord, due to financial hardship, lordship, she could not approach immediately, my lord. Paragraph 18, page 18, my lord, paragraph 18.
Documents annexed is very hard to believe. Look at page 50.
Yes, lordship, this is the PAN card, lordship.
Even all members in my family don't have.
Lordship.
Even members in there are few members in my family who do not have PAN card.
Parents voter list are there, lordship.
Why will a poor man have a,
Some things,
why will a poor man have a PAN card?
lordship. Nowadays, to open a bank account, sometimes PAN card is required, lordship.
You'll have to file another writ petition, take a gag order that the judges should not read what you call this, social media and then newspapers.
Lordship.
A very poor, very poor beggar was caught and was found to have assets of 30 crores. He was caught while purchasing a flat. This doesn't inspire confidence.
If parents are voters since 1966, lordship, I have annexed the voter list also.
There was an inquiry against you. You know that you have been charged of being, you are accused of being a foreigner. What is the best document you are having? Is connect yourself to your projected parents.
Lordship, the voter list of 1966 at page 31 is the
Your name is not there in 1966. That's
lordship.
not a good document.
Lordship is lordship has sought for the linkage, lordship.
No, whatever is, we asked, we are not saying linkage or any other.
Lordship,
We are
there
saying
is
best
a
document.
next to kin certificate, my lord, page 51.
Page,
51, 51, lordship. Though it was obtained at the later stage, lordship.
no, the next, we wanted to see before the.
The-
what you-
Page 51, Lordship, there is a next to kin certificate. Here the petitioner is listed at serial number 10 as a legal heir of his father Barkat Ali, who is a voter since 1966, my lord.
No, this I don't think is an exhibited document.
No, it was not exhibited, Lordship. It was obtained later on, Lordship.
No. Because the documents.
Lordship,
produced before the
admittedly, the case has not been conducted properly, Lordship, before the learned tribunal, Lordship.
That's something we can't
appears
presume
from the-
unless you give evidence that it was not properly conducted.
Lordship may call for the records at this stage.
No, the
Lordship.
records you have already annexed of everything.
Yes, Lordship.
What will the record have, except for some few Hajira and adjournment petitions? Now, please tell me,
Lordship.
my question may seem to be very absurd, or the suggestion would seem to be very absurd. It's just a thought which came across. Now, you have got this client. What will make you think that the client will have this document, that document, and then ask him to produce and then prepare a case? You expect the clients to give you documents. Was this document given to the lawyer and he threw it in the waste paper basket? You are accusing a lawyer, which amounts to, which
They
if
need to
accepted,
be
it
guided
amount
properly,
to
Lordship.
professional misconduct of that learned counsel. We are examining it. If it's a professional misconduct, we have to examine that allegation.
I'm not imposing allegation, Lordship, but these proceedings are very common when they are not aware of what documents are.
Every litigant is a common man. Tell me, name me few people who have you seen, big men in the courts. Showing your, which is the best document before the tribunal?
If there is a certificate of the Gaura Mela. But unfortunately, this Gaura was not called for to testify, Lordship. Page 46, my lord.
6. But this is an interesting certificate. I have no objection for opening bank account electricity connection. Where is your written statement?
Written statement, my lord, page 22 starts,
22.
page 22, my lord.
It examined two witnesses. Is it so? You examined two witnesses. Where is the witness of the second?
Only one, DW1, my lord.
Only one witness.
Only one witness, the petitioner only. Sorry, Lordship, DW2 is there, but the record is not available with us, Lordship. DW2 Abdul Quddus, it is recorded in the opinion, Lordship, page
That's why
55.
we are asking you.
Yes. That is, that I could not annex, my lord.
Who is Abdul Quddus? Who is this person, Abdul Quddus?
Father of the, no, my lord. Abdul Quddus. Father of the, no. No, Lordship, extremely sorry, Lordship. This is the judgment that I am referring. It is the judgment passed in respect of the husband of the petitioner, Lordship. He was declared an Indian, Lordship. That judgment I have also annexed in this petition, Lordship.
Okay.
So far the petitioner is concerned, my lord, there is only one witness only. petitioner DW one only.
Your father is alive?
No, my lord. Not allowed.
Where do we get the date of death?
22, my lord, page 22. 22 is the typed copy, lordship. The vernacular starts at 25. Forty-four, lordship. Lordship. Fashion. Yeah.
Nineteen sixty-three, madam. Annual Khiraspata, 1963. Yes. 14. This is not eligible, lordship. After the lordship 63. This is a document of 1963, lordship. Last Tariq. Yes. Yes, yes, lordship. But yes, lordship. And lordship. Yes, lordship. If you compare lordship, uh, it's just like 3 or 7, it is confusing lordship. All these things have been discussed in the opinion, Lordship. Yes. Exhibit 3, Lordship, may voter list, then Lordship. Yes, Lordship. Annual Kharaspata, name of Barkat Sheikh Sanam. On the other hand, on evidence on in chief as well as cross-examination has confronted her father is Borkot Ali, and there is nothing on record to show that Borkot Ali and Borkot Sheikh is one and same person. And Lordship, when they have shifted from earlier village to present village, Lordship, that was also not mentioned in the, not clarified by the proceeding, Lordship. WS is totally vague, Lordship. Name of the parents, grandparents, as well as place of birth, nothing has been mentioned. Okay.
When Zaman Lordship. My lord.
Hmm. Yes.
That is why Lordship may call. My- 64 is not overwritten.
Otherwise, also petitioner is no way connected, Lordship.
This document belong to her father, Lordship, Barkat Ali.
Item 19.
Obliged, Lordship. Lordship. Obliged, Lordship.
May I please, Lordship? My lord, this petition is also suffering for, my lord, delay approach to this honorable court. But here, my lord, petitioner has some explanation why, my lord, it is delayed. My lord. Order was passed, my lord, ex parte. Lordship, my lord, I beg to show, my lord, page 15, his, my lord, grandfather's, my lord, legacy. Then, my lord, page 17, his father's name, Hanif Ali, voter list of 1966. Then, my lord, just to show his link, my lord, one latest voter list, page 19, petitioner's name, my lord, Amiruddin Lashkar with his father, Hanif Ali Lashkar. Now, my lord, he has also submitted NRC application, page 22. This is the receipt of the NRC application. Now, Lordship, yes, ma'am. My lord, now, my lord, order passed page 29, annexure 10, ex parte order. Ma'am. Short ex parte order was passed on 26/2/2016. He submitted, my lord, written statement and affidavit also submitted, but he did not appear for cross-examination. Yes, my lord. Then, my lord, he was arrested. After arrest, my lord, I have stated the date, my lord, specific date. Paragraph page 17, my lord, he was arrested on 26/2/2016. 18/7/2016, he was arrested. Then he was released by the police on 26/8/2016. I have stated, my lord, at page 7. My lord, it is, my lord, I subsequently it is received, my lord, I this person. My lord, he was arrested, lordship, page 7 of my petition. 18/7/2016, he was arrested. Released on 26/8/2016. 2016. And immediately thereafter, he filed this review application. He is otherwise in continuous contact of my lord the police. And once even my lord police took him and my lord, in this case, my lord, I, my lord, personally believe that, my lord, there is a, my lord, communication gap, my lord, because otherwise, yes, my lord. Yes, my lord. No, my lord. Yes, my lord. Yes. But as per my lord, 18/7/2016, he was arrested. Released on 26/8, my lord. Yes, my lord. It is not mentioned in the application, my lord. No, my lord. Now, my lord, now again, my lord, he was, my lord, taken police, my lord, but my lord. Yes, my lord. Only, my lord, according to him, my lord, also kindly, he has stated, my lord, page 8, my lord. He genuinely states that, my lord, page 8, my lord, he was in Manipur. Since his childhood, my lord, he was staying in Manipur. And he occasionally, my lord, comes, my lord. He is a day laborer. And Code 8, my lord, there is a in a record, my lord, there is another bail bond. Okay. Here, my lord, he, according to petitioner, my lord, when this review order was passed, my lord, he was in Manipur, my lord. And this advocate, my lord, did not communicate My lord. No, my lord, this is also he is saying, my lord, but only, my lord, negligence, my lord, part is there, my lord, but valuable right, my lord, tribunal, my lord, on merit, my lord. Other family members are also, my lord, affected, and those, my lord, I, my lord, also enact one judgment, my lord, in the similar ground, my lord, dismissed, my lord, then, my lord, this petitioner approached before the Honorable Supreme Court, my lord. And the short order was passed, my lord, page 42. It was provided to, my lord, consider that case, my lord, on merit. Page 42, my lord, no, my lord, just it is to show, my lord, Corona period, my lord, page 40, my lord. Page 40 in my lord, lordship kindly have a look, it is also contributed, my lord. Then, my lord, all society people are, my lord, dispersed, my lord, scattered, were living in the somehow, my lord, somewhere. Page 40, my lord, second paragraph, my lord. In that view of the matter, the period from 15/3/2020 till 28/2/2022 shall have to be excluded for the purpose of limitation as may be prescribed under any general or special law in the respect of all judicial and quasi-judicial proceeding. The Commercial Code Act, the so and so and so. Well, negligence is there, my lord. The only thing. Yes, my lord. No, just it is just I am showing, my lord, this period, my lord. Yes, my lord. No, it is general, my lord. It is all my lord cases it was provided. No, 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 I'm not, with all respect, my lord, I cannot allow. Yes, my lord. No, 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 no. Yes, yes, my lord. This is, my lord, in another context, my lord.
Item 20.
My lord, I beg to, I may be allowed only one reference of one Supreme Court judgment regarding. Like,
Maybe lordships. For to impugn opinion lotwa is 129 lordships. Lordship. I'm deeply obliged.
21.
May I please your lordship, opinion is at page number 93.
Yes, Doctor. Amiruddin Law Court. Item 1919.
20.
Yes, Doctor. Yes, Doctor.
Lordship, at page number 93, opinion is of dated 31/10/25. Page number 93, Lordship. Yes, Lord.
22. 23.
May I please, Lordship?
Not amended, page number 63.
Lordship.
24.
Yes, Doctor. Yes, Doctor.
Lordship, Lordship, we have challenged the order passed by the Central Administrative Tribunal. However, Lordship, in this case, for this, the respondent was working as a 22, Lordship.
Item 24. 20. Standing hosted.
May I please, Lord? Lord, this is an expiry order, my lord. He is, my lord, at 47. 47 is the, my lord, imping order. My lord, he is in custody, my lord.
25/5/2025, my lord. Yes, my lord. Opinion is, my lord, 26/2/2021, my lord. My lord, in this.
The ex parte opinion.
No notice had been received by the petitioner, my lord.
Notice not received. Come to page 14.
14.
Para 19, serial number 4.
Para 19, my lord, the petitioner begs to state that in the voter list of 2019, the name of petitioner's sons, petitioner, and wife have been appeared. Yes, my lord.
After that, continue reading. Continue reading.
Yes, my lord.
19 is not yet over.
Yes,
Read.
my lord. His name is still in the voter list, my lord.
Please read.
Para 19, my lord.
Yes.
The petitioner begs to state that in the voter list of 2019, the name of petitioner's sons, petitioner, and wife have been appeared, namely as Alim Hussain, son of Ayub Ali, son of Lukman Ali, Rohima Khatun, wife of Ayub Ali, and Asikul Islam, son of Ayub Ali.
Yes, stop here.
Yes.
This is Ashikul Islam.
He is the son. He received the
He
notice.
received the notice.
Yes.
Page 47. He received the notice.
That is, I have, my lord, annexed the notice as well as the report of the police.
No, you just now said that notice was not served.
It shows that, my lord, the son, Asikul, he received the notice.
Yes.
But I have stated the, my lord, how and why, my lord, the petitioner did not gather the knowledge about the notice. I have stated at para 4, my lord. And my lord, the son, he just, my lord, attained his majority.
English at times is difficult language. What do you mean by just attained majority? Just would mean how many days, how many months, how many years?
My lord, now he is 25 years.
We are not on now. When he received notice, you said that he just attained majority.
Yes, my lord.
Just is very subjective. Just
My lord,
would mean what? Just would
So
mean
that, my
few
lord,
days,
we did
few
not
years.
know the gravity of the, or the importance of the notice.
We don't know many things. We wanted to learn today. What do you actually mean when you say just attain majority? How many days, how many months, how many years? What would be the meaning of
But
just?
actually, my lord, this is the fact, my lord. He forgotten to hand over the notice, my lord. And there the daily wages labor, my lord. He left the place.
Postman came and gave.
Because of that,
This notice is served by postman.
my lord, no, my lord, the process server.
And who is the
maybe
process server?
server.
Where is your process server report?
The report at page, my lord, 33.
33. Who is the process server here?
Process servers, my lord, the superintendent of police, my lord, page 33.
We don't know. You
Receipt.
know the document more. Tell us who is the process server here?
That is not mentioned, my lord. My lord, here, one notice there, my lord, মহামান্য বিদেশী ন্যায়াধিকরণ মহোদয় সন্মান সহকাৰে জনাও যে উক্ত জাননীত উল্লেখিত ব্যক্তিজনৰ পুতেকৰ চহী লৈ জাননী জাৰি কৰা হ'ল। আপোনাৰ বিশ্বাসী পুনানন্দ Sonwal.
That his designation is
This
there.
person.
Before that his designation is there.
Yes, my lord.
What do you mean that by that designation?
He is a person from court, maybe, tribunal.
This is SI police.
Yes, sir.
Yes. So policeman comes and he just receives the document and throws it away. Forgot about it.
My lord, actually fault on the part of them, my lord, the petitioner as well as his son. This is, my lord, real fact, my lord.
This is constable order.
No, lordship. Oh, yes, lordship.
Constable.
Constable order.
Constable order.
Constable.
Suman.
Constable order. Function form.
Huh?
Two constable even looks. Charge. Purnananda Sonwal and Kansan.
No, in my
Very brief person.
Otherwise, my lord, he has the documents, my lord. Only a chance may be given, my lord, because he is in jail, my lord, from last 8 months. Only because of, my lord, because of non receiving the notice, my lord, the petitioner did not appear.
2007's inquiry, lordship, now 20 years is going to be completed,
That
lordship.
is their part. Yes. 18. 20, my lord. Now he is 25. My lord, no, my lord, I personally asked him, my lord. He said that I have forgotten to hand over that is the fault, only fault. Because of that, his father is suffering, entire family is suffering. This is my lord, due to a fault, my lord, fault on the part of the petitioner's son, my lord. You know, this is the issue of citizenship, my lord. I am admitting, my lord, there is a negligence on the part of the petitioner. But a chance may be given, my lord. And he is, my lord. Lord, record may be for PCR may be called for, my lord.
Yes, sir. My lord, page 62 is the age of the person concerned who accepted the notice, lordship, who received the notice. Page 62, lordship. Asikul Islam, in the year of 2015, he was aged about 19 years of age, lordship. Yes, lordship.
Lord, PCR may call for at this stage. And let it examine, my lord.
Sixty-two, lordship. Asikul Islam, 2015, voter list, aged about 19 years. Lordship. Not after in the year of 2020, lordship. At that time, he was 24 years.
This discrepancy is there. Come page 64. 2019 voter list are 23 years. I say. My lord. My lord. Yes, my lord. Yes, my lord. Now, this is my lord. Another brother, my lord, Alim Hussain. He is not Asikul, my lord. Yes, my lord. 2020. 2020. 20. Yes, my lord. No, that is, I am also admitting that he was major at that time.
No.
Oh, yes, my lord. Yes, money. My lord, PCR. We allowed to cite some judgment, my lord. Tomorrow, my lord, tomorrow. Obligement.
We've challenged the order passed by the Central Administrative Tribunal, Lordship. In this case, Lordship, the respondent was appointed as a switchboard operator. For them, we have a separate time-bound promotion scheme. That benefit, she has already retired in the year 2015, availing that benefit. After retirement, after 6 years, she filed a petition before the Central Administrator claiming that she may also be given the benefit of ACP and MACP. Of a similar case, notice has been issued, Lordship. No, she is availed and retired, Lordship. We are paying her pension. Time-bound benefit promotion scheme, that has been, that benefit she has availed. And as per MACP, Lordship guideline, both cannot run concurrently. That will Lordship find at page 115. Serial number 13. Similar case notice has been issued. There is another one more case, Lordship. This is WPC 4877 of 2023. That case also, Lordship, notice has been issued. Under 15 serial number 13. May I read, Lordship? Existing time-bound promotion scheme, including in-situ promotion scheme, staff car driver scheme, or any other kind of promotion scheme existing for a particular category of employee in a ministry department for his office may continue to be operational for the concerned category of employees if it is decided by the concerned administrative authorities to retain such scheme. After such necessary consultation, or they may switch over to the MACP. However, this scheme shall not run concurrently with the MACP. So both the benefits cannot be availed, Lordship. This matter has to be examined, Lordship. First. Notice has been issued in the other cases, Lordship. Lordship, I'll take steps by register post, Lordship. Lordship. Deeply obliged.
Supply item 25 for motion.
My lord, matter the order passed by the Central Administrative Tribunal has been put to challenge, my lord, by which the transfer order of the respondent, my lord, has been interfered with by the Honorable, my lord, Central Administrative Tribunal. My lord, the facts of the case, my lord, if I may take, my lord, to page 17. My lord, the brief facts of the case has been stated in the order itself, my lord. The applicant, my lord. My lord. Yes, my lord. My lord. Was considered, my lord, at page 114. Page 114, my lord, is the consideration. This we have stated, my lord, in the affidavit which we have filed before the tribunal. Page 114, my lord. 15/7/2022. Order is there, my lord. Yes. My lord. In the reference, my lord, the representation and your letter dated 19/3/23. My lord. Yes, my lord. My lord. Yes, yes, my lord, this annexure has been filed along with the reply. So, my lord, before the representation was decided, my lord, the OA was filed. My lord. But he was initially, my lord, serving as deputy chief engineer in Agartala. My lord, my lord, my lord. My lord, my lord. Policy, yes, my lord. My lord, this is the comprehensive transfer policy for railway officers, my lord, dated 31/8/2015. If my lord takes Roman 7, if I may read, my lord, it says normally minimum tenure on a particular post at a time will be 2 years and maximum tenure will be 5 years. For sensitive post, maximum tenure will be 4 years. Now it is important, my lord, minimum tenure will not be applicable for junior scale, senior scale officers of group A. So, my lord, this minimum tenure in case of a, my lord, interzonal transfer from one zone to another zone, my lord, is not mandatory. The petition, the respondent herein, my lord, he was working in the NFR zone, my lord, from the year 2014. And since he had a long tenure, my lord, in that particular zone, my lord, he was transferred out. In the Malad to
Where's
a
the,
central zone in Hazipur, my lord.
where is the opinion, the tribunal's decision?
Tribunal's findings, my lord, the judgment starts, my lord, from page 16. I'm sorry, my lord, page 14, it starts from, my lord. The appreciation, my lord, starts from, my lord, paragraph 6 onwards, my lord, at page 25.
But then what do you have the reasons for the transfer first to Agartala and within a year to outside?
My lord, for that, my lord, I take my lord. I draw my lord's attention to page 109. My lord, page 109, my lord, is the communication by the chief vigilance officer, my lord, wherein due to the pending CBI case, my lord, against the respondent, my lord, there was a request from the chief vigilance officer, my lord Maligaon, that, my lord, if I may read paragraph 1, CBI AC New Delhi, wide above referred letter, copy enclosed has intimated the following regarding suspension of Shri Hemchandra Barua, Deputy Chief Engineer.
Just.
And under the Indian Railways Vigilance Manual, my lord. No.
Let me say, it's a for the analysis for the applicant. That's next. Agreed by the order dated. Nine 2025. Passed by this, passed by the Central Administrative Tribunal from our party bench. In OA numbers 152 of the 2022 and OA 185 of 2023. Each for the by which the order of transfer and posting in respect of the respondent were passed on 16/3/2022, on 29/3/2023, on 6/4/2022, 13/4/2022, and 3/6/2022, were questions and set aside. The present petition has been filed under Article 226 of the Constitution of India. Next one. Referring to the reason which required the transfer of the respondent from Gauhati to Agartala, and subsequently within a year from Agartala to which place?
My lord, first was Agartala to Gauhati, my lord.
From Agartala
And then, my lord, from Gauhati to
which place?
Gauhati to, my lord, East Central Railway,
East Central.
Hazipur.
East Central, white order dated.
My lord, 16/3/2022. Page
East Central Railway.
East Central Railway.
White order dated
16/3/22, my lord.
16/3/2022. It is submitted that there was a vigilance inquiry against the petitioner as well as CBI inquiry against the, it's not petitioner, respondent, and this is the set context as evidence was being collected at that point of time, there was a recommendation made by the Chief Vigilance Officer of NF Railway Marigaon to the CAO public CON-2 public Marigaon NF Railway from construction to transfer the petitioner sufficiently far off from the place of previous posting. Then bracket, page 109. Right, communication dated 18/6/2021. Next one. Review of the projection. Court is inclined to issue notice, return over on so and so, this is the date after 5 weeks. Return of so and so. Requisite steps shall be taken by the petitioners within 2 days for service of notice on the respondent who's properly. In addition, the petitioners shall serve notice on the respondent to thus the service by routing the process through the registry of the court. Upon service, an affidavit of service shall be filed prior to the next date of listing. Next part. Till the next date of listing. The operation of the order dated 9/9/2025 passed by the learned Central Administrative Tribunal from a party bench. What's this stay in? First place one school. OA 152 of 2021, OA 85 of 2022 have been stay. I also say issue notice. Same date. Steps.
Acknowledgements.
RT Marts.
So in this day order, you say is the the respondent is granted liberty to move this court for modification, alteration or modification of the order from expired. No. After advanced service of the, no, not by expired, this transfer. You bring this on record, otherwise we go without these documents.
No.
You should, not anything.
Item number.
I don't know. Okay. Take a slot, they can.
Daily list item 1 for hearing.
Over here, do we have?
Got that information?
Look, I have got the information, the investigate, as regard the investigation, no?
So speak to Mr. Chaudhary also. Speak to Mr. Chaudhary, by when will it be completed?
Look, in fact, in this letter I have received on 29/1, I have also had a telephonic conversation, Malak. She has, the officer has prayed for 2 months' time, Malak. Because of the law and order situation at that point of time, Malak. So it was going on, but the progress was slow, she indicated. She has prayed for 2 months' time, Malak.
But you see, this, all these matters where the There's a case of death. This. You must need something more than a vague statement about the law and order situation.
My lord, I,
There has to be a time bound completion.
My
Otherwise,
lord.
we say, give it to the other, give it to outside agencies.
my lord, the end, in
See,
the,
the 2 months is a very dangerous time you are asking. We anticipate the elections to come anytime.
that is,
Then again, 3 months, nothing will be working.
that is one factor, my lord.
Then
Yes.
we don't even know that in election time, whether this IO would be available or not. We have directions from this court also that the officers who are engaged in investigation works, they should be not given any other duty. 2013 people have died and now we are in 2026,
That,
13 years.
that's true, that's true,
Again, if they say 2 months time,
that's true.
better give it to somebody else.
That's, but I'll apprise them, my lord. Otherwise, this investigation is going on for a long, my lord.
We are dissatisfied. Right. We're keeping it on Monday. We're just adjourning it. We are not saying anything in the order. You tell us on 23rd, what do you intend to do? 2 months, after 13 years, 2 months more is.
Well, I'll apprise, my lord. I'll take it up with the authority and
Here, my lord,
I'll come up.
on day one, when we approached this honorable court, my lord, our, my lord, apprehension was that, my lord, that we won't be getting a fair investigation, because here
That's not the issue.
for 13 years, my lord, that's one.
It's not that. We do not have any evidence now.
That it
And
will
in
be
your
diluted.
favor- Your favor not to exonerate the people.
Only thing here, my lord, whatever has been collected, my lord, and that ministerial report, my lord. From there, it is apparent, my lord, we can show, my lord, subject to lordship on Monday. All these 3 children, my lord, they were school-going children. So they were attending their classes, regular students, my lord. And on the date of incident, my lord, 1 day prior to that date, my lord, they attended the annual examination. And the Caesar, my lord, that AK, there also, my lord, lordship would find, my lord, that there was no hand, that chance fingerprint, my lord. So all these things, my lord. And the other person, the petition number 3, my lord, he is also named as a hardcore terrorist. He was apprehended at the time of incident. Thereafter he was allowed to go. But no, he has been forced to involve himself. So he has been allowed to go. It's a case under Unlawful Activities Prevention Act, my lord. They have registered, my lord. So all these things, I leave it to your lordship. Definitely, my lord, that time span, my lord, 12 years, 13 years, my lord, that possibly cannot be, my lord, under any circumstances, my lord, be a case of fair investigation, my lord. They did not find anything till date. Possibly both the cases, my lord. One case lost by the petitioner side and the other case lost by the respondent side.
Even the state, if it wants, can give this police officer extra police hands for his security. To go to all those places where there is disturbance. You can increase the police force to give security to this IO. You can give him 1 battalion. You will read this Sirvai, Volume 1, Article 21. Do we have that book, Sirvai? Sirvai, 3 volumes. Very book of Sirvai. Constitution of India. Sirvai.
Oh, volume.
It's half green, half.
Yes, ma'am. It's a three volume book.
Three volume.
Three volumes.
Constitution of India.
Lordship has indicated which page, my lord, which,
Volume 1, Article 21 is there.
yes, yes.
Yes, case of James Murday. This is a case of 1962 in US, in Mississippi. What happened was, that at that point of time, there was that discrimination, color discrimination was there. So this James Murday wanted to join University of Mississippi, and there were protests not to allow him to join. And it is in this case that President of US at that point of time, John F. Kennedy, directed the federal troops to take him and escort him into the university. So an entire battalion of US Army marched with this James Murday to get him admitted in this University of Mississippi. It's an incident of 1962. That is very well detailed in that volume 1. We take a cue from there. See, for one student, the President of the United States could interfere, give army protection of one battalion of armed US Greek force.
To protect the right.
To protect the rights, uphold the rights. Why this state should not give this protection to this IO to go into that place to make an inquiry?
No, no, recently there was disturbance between.
We understand, that is so that
between groups, my lord.
take this case of James Murday.
No, she was engaged in the law and order maintenance, my lord, not because of law and order.
You have to bring him out.
Lordship. I'll definitely take up today also. Today itself, I'll take up with the SDM.
And my lord, in the meantime, my lord, those,
Otherwise we have other agencies who don't do law and order duty.
Lordship, that is there.
my lord, in the meantime, my learned colleague may go through the diary also because it was possibly called for, it was received, my lord,
He
scanned.
has the diary. Last
Yes.
time he produced it.
Yes.
So
Remember that.
what is the outcome or whatever has
He
happened?
would be prepared. He would be prepared, don't worry.
Yes.
We have no occasion to doubt when Mr. Nath appears and with the diary that is.
It was still, my lord, in the enquiry, my lord, the army personnel, they didn't win, my lord. They just gave the questionnaire, my lord. So whether they were interrogated or something like that, my lord.
We will get it when
Right.
once you get that schedule. But we just adjourn it.
Lordship.
We are saying nothing.
Lordship.
But Mr. H. Odil, also for the petitioners. Mr. Pursuant to the order dated 10/11/2025. The learned senior government advocate has produced a copy of written instructions dated 29/1/2025. Stating that the investigation of Runi Khata PS case number 28 of 2013 and 30 of 2013 could not be completed due to prevailing law and order situation in Kokrajhar district.
26. 29 and 26.
The said communication does not indicate the time frame within which the state police intends to complete the investigation. The next, the court expresses its dissatisfaction with the lack of clarity in the set communications sent by the additional superintendent of police within record time, record post to present. Next, accordingly, on the claim made by non senior government advocate, the magistrate judge on the enable him to obtain instructions list on 23/2/2026.
Much of it.
That
The
later maybe,
copy of communication date 21/2026 is written on record. You wanted to say something?
no, that will be kept on record. Can Lordship indicate that they have telephonically said that 2 months' time they have free? Can
No, then then you will be bound. We,
no,
then we'll have to defer your statement.
no,
Then responsibility should not.
Lordship.
We are conscious of it, well, we put
Mal-
it recorded, but we are not.
Lordship. Let me come up.
Sure.
No, Can I just pay for a copy, brother? The order copy.
Yes, you can.
Lordship.
Daily list item 2.
Just the court master will give it to you. He'll give it to you.
May I please, Lordship? Lordship, in this case, my lord, petitioner already died on 5/10/2023, my lord. And yesterday night, my lord, I have communicated the paternal uncle of the petitioner, my lord. And he has provided one death certificate, my lord. My lord, what happened in this case, my lord? A petitioner Ildersons is 14 years, my lord. He has only one sister, my lord. He has no any other brother, my lord. And now, my lord, petitioner already declared foreigner, my lord. His a consequence will be, my lord, annexus, my lord. I may be allowed to implement the minor child represented by the wife of the petitioner, my lord. Otherwise, my lord,
To do it, you file an application.
yes.
We'll consider that. We are adjourning it. On your.
Yes, adjourning, my lord, matter may be taken up after Ramzan month, my lord, after 18th of March, my lord. I think because, my lord, his wife may come to Gauhati, my lord, along with the child, my lord.
Mr.
Yeah, ma'am.
E.M. Ahmed, learned counsel for the petitioner, submits that yesterday he has received oral instructions, oral information that during the pendency of this petition, the petitioner, namely Muhammad Israfil Ali, alias Israhil Ali, has expired. So he is awaiting instructions. He also pays for a month's time to obtain the necessary instructions. Next, participants have done here. This give a date after 23rd of March. After 23rd.
After 23rd. Location. Mr. God bless. Location, but kita bagi point of the implement for the to better the knowledge of consequence to the rate of the yeah.
Item 3.
May I please, your lordship?
Yes.
May I please, your lordship, my senior counsel, AS Tapara is out of station, lordship. So kindly adjourn the matter, lordship.
Yeah. As a representative, the player made by the based again on. We did after 2 weeks.
Item 4.
May I please lordship, kindly this matter be adjourned for today.
Found the matter earlier twice, earlier player. First adjournment was on 10/9/2024, then 26/8/2025. Next time, no adjournment.
Lordship, kindly date may be fixed on next week, Tuesday or Thursday.
Says the representative, they have made an unconscious for the petition, but residents. Today, on the next date of the the matter will not be adjourned. List on 24/2/2026.
Item 5.
May please, your lordship. But here in this case, my lord, the improved opinion. Lordship will find at page 46. My lord, here, my lord, the evidence of TW1 was submitted, but whether he was examined was conducted or not, that I have to go through, my lord. I think there was no cross-examination of TW1. Mr. Sharma, just go through this record. We have not examined it because for looking into the records, we did not find time today. Here, what is you are required to check is Exhibit 7 is an opinion of Noor Islam, claimed to be the brother. Says to be not a foreigner. Says to be not a foreigner. Please examine that and tell us. Take it up after some time. At 2 o'clock, we'll take it up.
Next Tuesday, Lord. I will let this.
That is the only point. In fact, if that opinion is there, you check it. If you
Yes,
can't,
yes.
we'll then adjourn it.
Yes, Lord.
If you have time, look into it.
Yes.
If not, then we'll adjourn it. We are not averse on adjournment.
Yes, Lord.
2017 matter. We will. Other things will not be difficult, but this.
Yes,
this
yes,
is record for that opinion. Yes.
I will receive it.
Don't worry, if you are unable to, we'll adjourn it.
Yes, Lord.
Well.
Item 6 for hearing.
So Bharadji, you are sitting for which item?
Item number 11, ma'am. And that is, my lord, I say on behalf of Mr. J. Sharma, my lord. He is not well, so he couldn't come to court today, so he seeks adjournment, man. Matter may be adjourned. Item number 11.
Yes, I don't also for the discussion, if I understand that, John, this one, you take after 2 weeks. Okay.
Obliged.
Can you mark?
Reason of the mistake. Main details to be individual of hospital.
কিয় কৰা নাই?
নাই আৰু।
Six weeks মাতিব তেওঁ আছে।
Sorry, Lordship. I am for the petitioner.
Lordship, at page number 22, it was ordered that the petitioner could not prove establish link. So, case of the petitioner is decided in negative. So, in that sense, I have submitted some additional document, Lordship. Lordship, Lordship, at page number 48, page 48, page 48, Lordship, has a land document, Lordship, regarding more than income harassment, patta number, Jamabandi, photo, Jamabandi copy, where the father's name of the petitioner has been reflected, Lordship. And thereafter, Lordship, it's a sale deed. Page number 51 is the sale deed for purchasing of the land.
Which page is your written statement?
Pension for DW, evidence of DW1, Lordship in PCR, Lordship. In here. Page 40. Page 40 of TCI, Lordship, LCI. Page 22.
You did it. Then in fact, I have not yet. I have to ask on the petition. A copy of photostat copy I have. I have a copy, but it is a photostat copy. Photostat copy. And- mm. Yes. I ordered the digital center. So. 17/6/2008 ডাগৰ এক কথা বিৰহ এক বিঘা এক কথা
জমি মোহাম্মদ জলিল আলী জলিল আলী পিতা স্বর্গীয় তলেব আলীর নামজারি হয় 1808 Yes, yes.
আব্দুল জলিল
ইংৰাজী তাৰিখৰ চিঠাৰ 11 ইংৰাজী তাৰিখৰ হুকুমতে দানসূত্ৰে পাট্টাদাৰ লগত 608 নং দাগৰ ইমান কথা তুমি কুলসুম বেগম কুলসুম বেগম পিতা আব্দুল জলিলৰ নামে নামজাৰি কৰা হয় Yes, bro. Yes. Yes, proceed. Lordship. Yes. Six. But something confusing, Lordship. Dagor nong in third column, Lordship, third column. First Dag number is 513. 530. 508. 6. But here it was written as 6. 608. 6, 7. Is there not exhibited also?
Because this
Because of
document is
this
not
document,
known
not
to him.
exhibited.
But the question is in 2011, if the land is gifted, in 2015, how can you forget? It's not that you did not know about it. It's, if you have, you see, it's not an old thing that you forgot that you have a land. Land is something which people don't forget so easily. 2011 you get land, 2015 you forget. And now 2019 you come and say that I forgot to bring on record that we have a land and my father's name is there. Now your father's name, which is the voters list on which you rely. Whatever you rely to, it's Abdul Jalil. Correct?
Abdul Jalil, nineteen
Yes,
ninety-seven.
at page 47 is a certificate by you, where your father writes his name as Abdul Jalil Ali. When you got admitted in the school, you were minor, you did not know your father's name. Your father wrote this entry. He writes Abdul Jalil Ali.
First time appeared in 1997, Lordship, at the age of 40 years.
No, that is a part of the petition already decided. Now we are in review. We are trying to ascertain how you are proving your connect to your parents. Usually, do you have any voters list along with your father? No.
No, no.
So that means there's a disconnect twice. There's no voter list of your father and your grandfather together.
Yes.
And there's also no voter list of you and your father together. When you bring in a certificate which says your father's name is Abdul Jalil Ali, then you have the land purchased in the name of Abdul Jalil. Your the village also is changing.
Yes, sir.
All these things are discussed in the earlier order, Lordship.
Resume two.
Lordship.
Yes.
My humble submission is that the review will not lie against the order passed by dishonorable court lordship. There must be an error apparent on the face of the order, but there is no error apparent on the face of the order, and lordship. Another aspect is that lordship, if some new evidence could not placed by the proceedee, despite due diligence during the trial process lordship, that was that can that cannot be brought by the proceedee lordship, and lordship in Kamalesh Verma's case lordship. Two 2013 8 SCC lordship T20 lordship para 20 and 20.1 lordship clearly
Just a
Discuss.
moment, please repeat again.
2013
13.
8
T20.
T20 in para 20 and
What is the
20
name of the parties?
Kamalesh Verma.
Versus Maya.
Yes. Lordship in Mayavati and others. In para 20 lordship. It has stated that lordship does, in view of the above, the following grounds of review are maintainable as stipulated by the statute. 20.1, when the review will be maintainable, discovery of new and important matter of or evidence which after exercise of due diligence was not within the knowledge of the petitioner or could not be produced by him, and mistake or error apparent on the face of the record. Then lordship para 20.2, lordship, it was then when the review will not be maintainable, a repetition of old and overruled argument is not enough to reopen concluded adjudications. Minor mistakes of inconsequential import. Review proceedings cannot be equated with the original hearing of the case. Review is not maintainable unless the material error manifest on the face of the order undermines its soundness or results in miscarriage of justice. A review is by no means an appeal in disguise whereby an erroneous decision is reheard and corrected but lies only for patent error. The mere possibility of two views on the subject cannot be a ground for review. The error apparent on the face of the record should not be an error which has to be fished out and searched. The appreciation of evidence on record is fully within the domain of appellate court. It cannot be permitted to be advanced in the review petition. Review is not maintainable when the same relief sought at the time of arguing the main matter had been negatived. So, lordship, here my humble submission is that, lordship, there is no error apparent on the face of the order passed by this honorable court, and so, lordship, this review petition is not maintainable, so it may be dismissed, lordship.
Lordship, it is also maintainable, Lordship, as it is held in state of Rajasthan and under versus Surendra Manhat and others in the case of 2014 14 SCC, page 77, Lordship. I'll supply. Okay. However, state of Rajasthan and another versus Surendra Mahanat and others. 2014 SCC 77. Only review can. Paragraph, I'm relying on paragraph number 22. Okay, however, Lordship, I pray for another thing, Lordship. Lordship, since page 49 of this review application, the certain fact need to be ascertained with original gift deed. I think I feel it with Lordship. So let me try to ascertain whether the gift deed is in the hand of the petitioner
No, we don't
or
need
not.
that.
Okay,
You,
if
for
your
the
Lordship
purpose
can
of
permit
relying-
me.
No, you see, we can't enlarge the scope. You have given us a document, we are just trying to analyze that.
Okay, Lordship.
Analysis of one document leads to another document.
Yes.
And you should have taken a call then.
Lordship, in page number 36, Lordship, there's a voter list where linked with the father of the petitioner with his grandfather, Lordship. There's a document which is also exhibited in trial court also. Page 36 and page 37 is, page 37 is that it is a link between father of the petitioner with his grandfather. Grandfather. This document also ignored by the court below at the time of deciding the case of the case.
Together? No.
So, 1997.
1997 is, father's name is Taleb. Which Taleb we don't know.
So
Which Taleb we don't know. Any voter list containing your name and your mother's name together?
in 1970, Taleb Ali, the voter is page number 35.
Then Taleb Ali becomes Taleb, tell us why, how?
Now permitted.
2018 passed by this court in WPC 4151 of 2016, by which the writ petition was dismissed without interference with the order, with the opinion dated 17/6/2016, passed by the learned member, foreigners tribunal number 4, Kamrup at Jo in HFT case number 352 of 2015. Within bracket new. Rising out of page 23, rising out of IMDT inquiry numbers also. Whereby the petitioner was declared to be founder of hospital practice in 1973. Next up. This review has been referred on the ground that in his cross-examination, the DW3 that the father of the petitioner was engaged as a laborer in his house for about 5 years. Thereupon, we stated that in the set ground from a complex arithmetical calculation of the age of several persons in the relation of the petitioner has been calculated. And it's predicted that the said calculations were overlooked while deciding the writ petition. This, what do you mean by this word? Matrices. In page 9 of your review petition, you have used the word matrices, matrices. What is the meaning of this word?
Page 9.
First, second paragraph you have used upon following three matrices. What is the meaning of this word matrices? matrices.
So. Matrices.
In respect of exhibit E, exhibit F and exhibit D, which is taken to have been overlooked and unconsidered by this court. Referring to the process that we will. As a second round of review, it is projected that during cross-examination of the unit before was the father of the petitioner. He had stated that DW4 would produce a sale deed before the tribunal. But the same remained surrounded in mystery. One thing, page 8, 8, 9, 10, 11. Yes. Copy this and paste it. What is this solution of is further submitted that the petitioner has been able to lay his hands on the certified copy of Jamabandi of Forester Revenue Circle under Korba, KAURBHA, Korba, Moza of village is NIZ RAUREAHA, Ms. Raul Baba, NIZ RAURBAHA, covered by pattern number 345. It is submitted that they said document leaving the petitioner with his projected father. Accordingly, comment is submitted that the petitioner be given an opportunity to leak further evidence after remanding the matter back to the learning side. In support of the submissions that a review would be maintainable for new and additional documents being produced. What the learned counsel for the petitioner has placed reliance on the decision of the Supreme Court of India in the case of State of Rajasthan versus Surendra, SURENDRA, MOHNOT, 2014, bracket close, 14 SCC 77. Within that, I think it will be. Moreover, by referring to the entries made in the voter list of 1997 within bracket exhibit D, that submitted that in the said voter list, the voter is Abdul Jalil, ABDUL, Jalil. And the name of his father is shown as Taleb. Accordingly, it is submitted that the petitioner has been able to show the link between the petitioner and his father. Anything else you told us? We forgot. Have you forgotten anything?
No.
Any other submissions did you make?
Lordship, Lordship, regarding page number 49, regarding doc number, whether it is 508 or 608, the page number 49. Lordship, there is nothing contained in any note reflecting that there is anything written regarding referring doc number 508 in that page.
Okay, you can show it to anyone. We can take anyone as a.
If
like
that
that.
it is
You
508.
can just turn around and look at any of your friends sitting behind.
608.
Let them, anybody read it. If we can read, anybody can read this.
It assumes to be 508, but there's nothing in the note that
That's why.
in respect of doc number
You
508.
see, you are producing a document.
Yes, Lordship.
We are just reading it. You can show it to anyone. There's young lawyers are there who may not have an opportunity of addressing the court immediately. Yes, madam. Please come forward. You can read SMS. You read this.
Itu 5 pass ko at nisna lagi sila so far.
Is it 5 or is it 6?
Is it 5? It's fine.
Thank you. We called you as a young lawyer who may not have very recent experience in arguing before the court, so we gave you an opportunity. Yes.
It's nothing that.
We are reading what is there.
Yes.
And I read it with the caveat. But this is not my mother tongue. So when I read, I could not, therefore I send it back to you so that you can read. I may not make a mistake. This is not my mother tongue, it's my acquired language.
Yes.
Oh, sorry, third language. For me, huh? For me, third language. Not acquired language, I'm sorry. That's with third language. Next. For contrast, from the learned standing counsel for the FP matters has submitted that elaborate argument is advanced by referring to the grounds of review. Might be submitted that an excessive argument is being advanced to show by various arithmetics the age of various persons whose name appear in the voters list being the voters list of 1997 within bracket exhibit D, voters list of 1966 within bracket exhibit E, and voters list of 1970 within bracket exhibit F. Accordingly, it is submitted that if there is a inherent error in the appreciation of a document, it would be an erroneous finding and would only be amenable to a to be corrected in a appeal, and review would not lie. First of all. Accordingly, moreover, it is submitted that the new document being the Jamabandi of the land would not be said to be a new document which came to the notice of the petitioner after despite the due diligence, exercise of due diligence. Instead of accordingly, by referring to the case of Kamlesh Verma versus Mayawati, within bracket 2013, bracket 8 SCC 3Q0, it is submitted that a review would not be maintainable. Anything we have left out?
No, Lordship.
Next. You consider the materials available on record and give due consideration to the grounds of review which is extracted here before. In order to explain the error apparent on the face of record, the petitioner has shown the complex arithmetical calculation to justify to find fault with the finding of this court. First, in this regard, it may be stated that this court, while passing the order dated 15/11/2018, passed in WP C5141 of 2016, had considered each and every document and exhibited documents. Refer to the age reflected in the various documents only to arrive at a finding that the plea of the petitioner of shifting from Bangalpara, BANGALPARA, Bangalpara to Ms. Kaurava, NIZKAURBAHA, cannot be accepted. By holding that the oral evidence regarding the migration of the grandfather and his family from Mangalpara to village Nis Kaurabha, Nis Kaurabha, NIZKAURBAHA, 40 years back, cannot be held to be proved on the face of contradictions of the DW 2 and 3. This court has held that the submissions of the learned counsel for the petitioner, that oral evidence remains unrebutted, cannot be accepted inasmuch as when there are contradictions amongst the witnesses produced by the petitioner and their versions are recorded, the same forms part of the evidence of the petitioner put on record in order to discharge the onus, ONUS, onus dash probandi, PROBANDI, consistent with the fact in issue. In the next, in the considered opinion of the court, by way of elaborate definition. The analysis has to be made by a by the court in exercise of review jurisdiction. It would not be a case of review, but it would be a case of fresh appreciation of the evidence. And that the error apparent on the face of record cannot be found out by a merely by looking at the documents in the order of this court. Accordingly, the case of Surendra Mahano, LSURENDRA, MOH, within bracket Supra, started by the learned counsel for the petitioner does not come to the aid of the petitioner. Next one. The learned counsel for the petitioner at least glance on paragraph 22 of the case of Surendra Mahano. The same is reproduced here and below. Paragraph 22. Start this in KRIBAN, Kuleshwar Sharma. That case is given. From the said part of the order in which reliance is placed, it does not appear that when by elaborate arithmetical calculation a mistake is to be found out, it can be said to be an error appearance on the place of record. And not an and that the decision was not erroneous on merits. Next one. The learned counsel for the petitioner had this reliance on a copy of Jamabandi relating to Patta number 345 of village NIZ RAURDAHA under Korbaha KAURDAHA Korbaha Moza. Though the document annexed as an HSJ is not a true and correct translation of the Jamabandi, but on perusal of the vernacular document, it is seen that one Mohammed Jalil, MD, Jalil, Jalil, Ali, acquired title in respect of a plot of land by way of sale and transfer in respect of doc number 608. Full stop. No, 508. Full stop. However, the said entry is at remark column number job CHA. Which refers to purchase of land in connection with doc number 608. So therefore, there appears to be a difference between the doc number of the land, which in column 4 is mentioned as 508. But in the remark column, the same is mentioned as 608. First of in this, in so Sharma, again, same difficulty. Page 49. The side is the middle one which you read earlier is jaw. Correct.
Yes.
Next is which one? The next is what? Yes, this one is, I can't read again.
Okay, it is fine.
You see, we are not following it because you see, first, Mr. Sharma and Mr. Ali, at the, above what you are reading is ko.
Yes, Lord.
Correct. After ko, there should be kho.
Correct.
But we are not finding this ko, suddenly this chaw comes in this middle.
Middle.
And then here again, this word I can't read.
It's look like, oh.
It is not jaw, I can't read this. Mr. Kugan, you can read better than us. Assist us in telling us the number.
So only 3 more.
Start it again.
It will go.
Mr. Sharma, have elementary education.
So,
I just say that if the next remark, which the number of which could not be read, despite effort by the learned counsel for the petitioner and all the learned counsel for the respondents. The land revolved on the petitioner was by way of give deed. And the corrections in the land revenue records is made in the year, made on 14/2/2011. And the correction entry made on. Huh?
it is not soy, this is Modneto and light one is Modneto. This
is
because the serial number also, let's say in left side, 1 and 2, thereafter, they have left certain person, again, it started from 12, 13 and 14.
Yes.
So maybe it's maybe a long document. So in between, there might be a certain orders, they have not noted it down. Then after Koho, then it is Modneto and Modneto, I guess. Maybe Modneto, it looks because only these two words resemble Modneto and Modneto also resemble.
It is not performed so, Lordship, because there is a, not so, Lordship, because in top it is a market. Or modernate and modernate for that. Size is less. Not top, huh? The date of correction of the order would not be right. So therefore. It's from the. It appears that the petitioner received a land by way of a gift, for which corrections in the land revenue records are made in 2011. And therefore, it is not possible for someone getting land by way of gift in 2011 would forget the existence of the gift deed and connection of the petitioner to her father in 2015 when the proceedings was proceeding before the foreigners travel had commenced. The written statement of the petitioner was filed before the foreigners travel on 29/12/2015, which does not contain the reference to the gift deed of the land revenue records. And the evidence on affidavit filed by the petitioner number 1 on 29/12/2015 also does not refer to the set of. Yes, sir, Pama. This is not a case where any document came to light subsequently after the proceedings before the learned foreigners tribunal or after the proceedings in the writ petition was concluded. So it appears that the land revenue records are now being sought to be introduced only to fill up the lacuna. As neither the learned foreigners tribunal nor this court could find the link between the projected grandfather of the petitioner and the projected father of the petitioner. And there's also no documents to link the petitioner with his projected father, with her projected father. The learned counsel for the petitioner had made strenuous effort to show that show from the voters list of 1997 that it contains the name of the projected father of the petitioner and projected grandfather. However, same cannot be accepted as the said voters list do not contain the full name of the grandfather. There is no other contemporaneous records, contemporaneous records establish that establish a linkage between the petitioner and his father and the linkage between the father of the petitioner and the projected grandfather. Next one. The you have the law laid down by the Supreme Court of India in the case of Kamlesh Verma versus Mayavati within Beckett. Within this edition, if given with you, then it's to Kamlesh Verma circular. No ground for release laid out. Next one. Accordingly, the no this and the same is dismissed. Next paragraph. And consequences of the opinion dated 17/6/2016 passed by the learned member among foreigners tribunals number 4, Kamruk at Hajo in HFT case number 352/2015 within bracket new bracket close arising out of IM within bracket T bracket close P inquiry number 1608 of 2003. By which the petitioner was declared to be a foreigner was from so it has not come to the notice of the court that there is any interim order passed in this review petition. Nonetheless, it is provided that in the event there is any interim order passed in this review petition, the same would stand negative forthwith. There's no interim order, but still we have said, if there's an interim order, it will stand with it. The registration will send back the records of the, not the registry. You can send it to the home.
Yes, sir.
The learned standing counsel for the FT and border matters shall communicate downloaded copy of this order to the home and political within bracket B, close department, just to transmit the same to the jurisdictional tribunal. Sir, it Kamlesh Verma, number 20. Paragraph 20.
Keep blessed.
Siddhar, you have seen this matter?
Yes, Lordship, I have seen, I think, Lordship,
Mr. Siddhar, you can come forward.
yes, Lordship, I have seen that. I think, Lordship, some hearing is required in this case, Lordship.
Please another date.
Lordship.
When?
Well, next week, Mela.
Lordship.
What says it represented? The Let's see, because you'll be rising at 3:30. We say that books are the representative, the possible time matter could not be taken because they will take this one. We're saying next week. Just see this question. When this six
Deep level business.
Item 7 for hearing.
Nine. Lordship, I don't have the copy, Lordship, if possible, Lordship. I don't have the copy, Lordship, one copy maybe.
What says it representative? So G Sharma, where I can also the. What are the aspects? These values appears to have been misplaced. Provide a copy of the requisition to the copy of this, and first for the editing bottom address. Hearing is a term, just.
Lordship, any date, Lordship.
Tenth of March.
Okay.
Yes.
Item 8 for hearing.
ক্যালসিয়াম দুটো না এটা আছে। আরো এটা আছে, দুটো আছে। No, first mill, there's an order, first mill, when it was first day order, 29/5/19. In middle mill, there is a little, that one case was proceeded against my brother, and he was declared as an Indian. And that case number, Millard, is application number 869/2018.
We have the records.
Millard?
We have both the records.
Millard, there is no, he, my, could not say one record. Both are there, yes.
But your brother came from where? Did you say about your brother in your written statement?
Yes, it also Millard declared in the Millard. WS.
Mentioned in the WS.
Probably it was not mentioned WS, but in judgment there is come.
What is the name of your brother?
Shahadut. I have given judgment also, Millard. Page Millard, that is 48. I received notice from the tribunal. I filed reinstatement and also a DW. For my, I am DW1 and
Just a moment.
my lord.
But please tell us. Which page is that opinion of your projected brother?
Sorry, my lord.
Your projected brother, what is the date of opinion? Which page is that?
Yes, my lord. I have seen that is my lord. That opinion, my lord, is 3/12/2018.
C12 2018.
18. And in my order, my lord, that is 24/1/2019. So after a few days, not more than that. Same rate, 24 or 25 days. And we received the copies, my lord, on 3 days.
No, but the point is that why, if cases are going on against both of you, why you did not, both of you did, what you call, you did not disclose about your brother?
I have mentioned in WS Miller so that I have, we are brothers, sisters, I have mentioned. But
Just now you said it is not mentioned. In the written statement, did you give, did you name your brother? We did not see it.
Coming here.
Just now you said it was no.
Yes. Your lordship is right. That point is not there in the piece.
Not there. Why would you not give?
Actually,
And-
both,
and
both
you see
in the,
this-
in the same court, both the cases are going. So they both the cases could be take together, my lord.
No, you see, it's very difficult, Mr. Rashid.
My lord.
There are many learned counsels sitting here. I may not know the relation of A with B. I'm finding them daily in the court. But if there is some relation between A and B, I don't know. How will the tribunal know?
Definitely, my lord. Your lordship is right.
Definitely no.
We are, my lord.
Okay.
Yes, your lordship is right. There is a, both the cases
No,
could
that's
have
okay.
been take together.
But no. Our opinion came in 2018.
18 and, but only 24 days difference.
No. Maybe 1 day difference. But what's prevented you from bringing, from referring to that? Your brother did not bring that on record. Neither you brought your brother on record. Your opinion is first on point of time, second on point of time.
Second.
First is your brother, but still you don't bring your brother.
No, brother was, that is 3/12/2018 and mine is, so a few days later, that is 24/1.
Then also you don't bring your brother. That's the problem. He did not give evidence in your case.
Only evidence was I myself and one of my cousin and our Latman.
When you have your own brother, why you bring your cousin?
Only it's 22. My first model is page 36. And vernacular Miller, page 37, annexure 9. 85. My. A TPF Millet, I have given translated copy and also Millet the certified copy, yes. Certified copy Millet page 37. But there are some spelling mistake is there. It is a Khushal Mandal, but it is Hasan Mandal. Father's name Hasan, is Khushal, but that kind of correction, neither they have applied, even they do not know whether it is wrong or right. Thumb-branded person.
One thing is there are two things, neither in the nor in WS Lordship, nowhere mentioned that Lordship, his brother's names are not mentioned Lordship, and in the any of the Bhutanese Lordships, his name and his brother's name is not. Page 43 Lordship.
I have not asked you. Once. Sometimes names are there, sometimes not names. Yes, I can say it. Name correspondent Shahidul Islam, yes, similar. Same. This
Yeah, it is there, in brother's case, it is there, but.
no, it is sorry, Mirad. In my case, it is applicable. Earlier was Shahidul Islam, now it has come Rafiqul Zaman. So separate.
In brother's case, it is there, Lordship, and but in his case, Lordship, documents placed by him, Lordship. Yes, Lordship. Lordship.
No, I was just check. Without checking, I said it. So after checking, it is found names are different. And that can same and unfair also.
After 7th of March. Because Lordship, in this case, Lordship, Mr. Banks and his reviewed Lordship.
10th of March.